Hi, I'm Jason Sullivan of the Rathbone Group, and in this video of On Subrogation, we're going to continue a discussion of relevant evidence under the Federal Rules of Evidence. In our prior video, we talked about cases where the court might decide to exclude evidence based on the fact that it would mislead the jury, that it was unduly burdensome and going to slow down the trial process, or that it would confuse the issues. In this episode, we're going to talk about specific rules that set forth types of evidence that the court is just not allowed to accept. In those other cases, the court has a lot of discretion and leeway in what is allowed to be admitted. In these cases, the federal rules set forth types of evidence that are just not admissible. The first thing we're going to look at is character evidence. And under the Rules of Evidence, Rule 404, character evidence is not admissible to prove that someone acted in conformity with that character type. Take a subrogation case where there's a town drunk, someone who is known to be habitually under the influence of drugs or alcohol. This person is driving a vehicle and gets into a motor vehicle collision. The plaintiff in that case could not put forth evidence that that defendant has the character or reputation of being the town drunk or someone who is always under the influence of alcohol. That character evidence can't be used to prove that they were drunk at the time of the collision. In those cases, it's going to be more prejudicial to that defendant than the court's going to allow. Rather, the plaintiff has to put forth specific facts. If the plaintiff can put forth facts that when the defendant exited his vehicle, that the defendant was slurring their speech, that they were having trouble walking or communicating, or that they smelled like alcohol, all of those things would be admissible evidence to show that the person is under the influence of alcohol or drugs at the time of the collision. But evidence that this person is habitually drunk or is known as the town drunk or is always under the influence is not going to be admissible to prove that they were under the influence at the time of the collision. Similar to that, under Rule 404, prior crimes are not admissible, again, to show that a party acted in conformity with that crime. If a defendant in a case is accused of running a red light and causing the plaintiff's damages, evidence that this person has 28 prior running the red light tickets is not going to be admissible evidence. Again, the same reasoning. You don't want the jury to make a decision that the person is at fault because they previously ran 28 red lights. Rather, the jury needs to make a decision that the person's at fault because they ran a red light in that particular instance. So the prior crimes are not going to be admissible to show that the person is at fault for this particular instance. For both of these, character and prior crimes, there are important exceptions for subrogation cases. For character, a lot of times character can be an element of a claim that you're making against a party. Let's take someone, you're insured, they own a home and that home is burned down. Who started the fire? Turns out it was a neighbor boy, 13 years old. Now, you might have a claim against the child, if they're 13, or even better, 14 or 15, that they were negligent or intentionally set the fire. But what about the parent? Don't they have a duty or an obligation in this case to make sure their child doesn't set fires? So you may have a claim for negligent supervision on the part of the parent. What is going to be great evidence that the parent had a duty to supervise? Well, if that child has set fires previously and the parent was aware of those fires, the parent would have a duty to keep fire-starting materials out of that child's hands and to supervise them. So as the plaintiff, you're going to want to put forth evidence that the child set forth prior fires, that the parent knew of those fires, and therefore the parent had a duty to keep lighters off of the kitchen countertop where the child had them accessible, and to not leave the child unsupervised at home alone for long periods of time with access of these things. The parent needed to supervise this child because of their knowledge. Now, to show that the parent had knowledge, you're going to have to put in evidence that the child previously had started these fires. For the criminal exception in the subrogation cases and in civil matters, if the crime which a person was found guilty or pled guilty to shows an element of your civil case and it arises from the same facts, that also may be admissible. So in our red light runner case, those prior red light running cases are not going to be admissible to show that they ran the red light in this case. But let's say that we're dealing with something that's more like a felony as opposed to a traffic infraction. This person had ran a red light, they had hit an individual and killed them, unfortunately. And so now there was a vehicular manslaughter charge that rises to a felony level, which means that it was possible that they'd get more than 1 year in prison. If the person pled guilty or was found guilty for that exact same offense arising from the same loss that you're now suing them for in civil damages, that guilty plea or that jury verdict would be admissible to show that the person was operating a vehicle in a reckless manner or under the influence, and the jury verdict or the guilty plea would be admissible evidence that the person actually did commit that crime. So even though prior crimes are not admissible to show conformity with that action, if someone pled guilty and it needs to be a felony type case, you can use that if you're pursuing a civil claim out of that same circumstance that led to the criminal charge and then conviction. Another item that the federal rules keep out of the jury is just not admissible evidence, even though it might be relevant, is prior settlement offers. The reason for this is that they want parties to try and resolve claims before they go to court or before they go to trial. And if parties know that if they make a compromise offer that that's going to be used against them at trial, it's less likely that they'll use it. If you're handling subrogation claims, you might see this quite frequently. Correspondence from an attorney or an adjuster may say things like, this letter being sent under Rule 408 settlement offer protection. That language doesn't have to be on there to provide that protection. That rule exists whether or not that sticker or tag is put onto the communication. But again, the point of that is that the court and the judicial system wants parties to freely negotiate and exchange offers and try and resolve cases without the court intervention. This rule helps promote that. Parties can now make an offer to compromise, settle for 50%, 75%, and the other party cannot come back and say, well, clearly you're at fault because at one point you were offering me 75%. That would confuse and mislead the jury in most cases, and so it's just not allowed. Finally, the other issue that we're going to talk about is Rule 409, and that's offer to pay medical expenses. Similar concept as with the offers to compromise. The courts don't want to penalize someone who benevolently comes forward and says, I'm really sorry about this accident, let me pay for your medical bills. They want injured parties to receive treatment and have those bills paid for. One big key distinction between Rule 408 with settlement offers and Rule 409 with offers to pay medical bills are that in the settlement offer context, all statements related to that are excluded from the court. So if you were to write a letter that says, I know that my party ran the red light, but they were doing so because of an emergency situation, we're willing to offer 50% to make this go away. All of those statements in that letter or communication are not going to be admissible. They're all included in part of the settlement negotiations, and under the federal rules, they're not going to be admissible to the jury. For the offers to pay medical bills, the court in the federal cases separates the statements of fact separate from the offer to pay medical bills. So let's say there's a motor vehicle collision and the defendant gets out. They run up to the plaintiff and say, oh, I am so sorry. The sun was in my eyes. I know I had the red light. I'm really sorry. Don't worry. I'll pay for all your medical bills. The court is going to look at that offer. Don't worry. I'll pay for all your medical bills. And that would not be admissible to the jury. But all those prior statements about the sun being in their eyes, running the red light, they know it's their fault, that would still be admissible. So when you're looking at the two things, settlement offers and discussions is going to exclude all of the context of the situation. If you have a party, you're insured, who made those types of admissions, it was my fault, I'm sorry, even if it was attached to an offer to pay medical bills, that's still going to be included because the court's going to separate the statements of fact from that actual offer. And then finally, the last thing we'll talk about is lack of insurance or existence of insurance. Under Rule 411 of the federal rules, whether or not a party has insurance is not admissible to the court. The reason for this is we don't want juries to award damages against parties on the mindset that it doesn't really matter if they're at fault or not, an insurance company is going to pay for it. We also don't want juries to not award damages because a party didn't have insurance and they feel sorry for the defendant and don't want them to have to pay out of pocket. So the existence of insurance, whether they have it or whether they don't have it, is something that the courts just don't want juries to consider. It's not admissible evidence, and under Rule 411, that's going to be kept out. If you have any questions on any of the subrogation topics in this video or other videos, please email us at video@rathbonegroup.com. For Rathbone Group and On Subrogation, I'm Jason Sullivan, and that's the long and short of it.